Hello and welcome. My name is Alan, and we are back with more notable names in Jewish American history. Nope. That's better. I was trying to figure out, it's like, it's not looking at me right. Anyway, today we are looking at United States Supreme Court Justice Louis Brandeis, who himself is of Jewish heritage. He joined the Supreme Court on June the 5th, 1916, replacing Justice Joseph Rucker Lamar. He was born on November the 13th, 1856 in Louisville, Kentucky, and in 1877 graduated from Harvard Law School with the highest grade point average in its history, so clearly intelligent. Shortly afterward, Brandeis entered private practice. In 1890, he published an essay called The Right of Privacy, or The Right to Privacy, in the Harvard Law Review, which greatly influenced the direction of law in this field. He also became known for the Brandeis brief in the 1908 case of Moeller versus Oregon, and marshaled a massive amount of non-legal data rather than relying on his legal analysis in the brief that he submitted to the U.S. Supreme Court. He helped persuade the court to uphold a law restricting the working hours of women despite the general tendency to strike down economic regulations during this era. Yeah, remember, this is just following. We're on like the tip end of the Gilded Age. We're coming out of that late 1800s Rockefeller, Carnegie period. So, yeah. After Woodrow Wilson won the 1912 presidential election, Brandeis advised him on economic policy, and among other things, he contributed to the creation of the Federal Trade Commission. January 28, 1916, Wilson would nominate him to the Supreme Court, and despite fierce controversy surrounding his nomination, the Senate would confirm him 47 to 22. He would take the oath of office for the Supreme Court 4 days later, becoming the first Jewish justice in the Supreme Court. During his quarter century on the court, he defended the freedom of speech under the First Amendment, and his concurrence in Whitney versus California declared that fear of serious injury cannot alone justify suppression of free speech and assembly. Brandeis also developed the right to privacy that he had described in the Law Review article in a dissent from the later overruled decision of Olmsted versus U.S. He wrote that the Constitution provides the right to be let alone by the government. Joining Justices Benjamin Cardozo and Harlan Fiske Stone, he was one of the liberal Three Musketeers on the court, and they opposed the conservative bloc known as the Four Horsemen. Like the other Musketeers, Brandeis generally voted in favor of New Deal legislation and similar economic regulations. He would retire from the court on February 13, 1939, being replaced by Justice William O. Douglas, and he would die October 5th, 1941, 2 years later in Washington, D.C., and be buried in Kentucky under the portico of the University of Louisville Law School, one of the many educational institutions that now bear his name. Some opinions by Brandeis. We've got Erie Railroad versus Tompkins. The federal court exercising diversity jurisdiction must apply the state law as declared by the highest state court. There is no federal general common law. Lawsuits and legal procedures. From North American Oil Consolidated versus Burnett on the regards of taxes. If a taxpayer receives earnings under a claim of right without restriction to its disposition, he has received income that is required to return, even though it may be claimed that he is not entitled to retain the money, and even though he may still be adjudged liable to restore its equivalent. They give a number of cases and his opinions. We got antitrust, healthcare, free speech. So yeah. But from Oye, Louis Brandeis was the son of Jewish immigrants and was born and raised in Louisville, Kentucky, where his father was a successful grain merchant. Brandeis entered Harvard Law School when he was 18 and earned the highest average in the law school's history, graduating in 1877. He came to the Supreme Court with extraordinary credentials as a lawyer and public figure, and proved to be equally extraordinary justice by employing the skills that made him renowned as an attorney. He mastered procedural details, researched the facts and the law, and went to great lengths to fashion opinions that were clear and logical. For Brandeis, law was a device to shape social, economic, and political affairs. Law had to operate on the basis of two key assumptions: that the individual was the basic force in society, and that the individual had limited capabilities. Brandeis did not seek to coddle the individual, rather he sought to stretch individual potential to its limit. It is difficult to isolate a single opinion among the hundreds that Brandeis wrote. However, or whatever the choice, some student will surely take exception. However, the opinion with the greatest impact on the law must be the federalism case of Erie versus Tompkins, one of the last decisions Brandeis wrote. So yeah. But yeah, he was of Jewish heritage, born to Frederica Dimbitz and Adolf Brandeis in Louisville, Kentucky. From Britannica. He was a lawyer and associate justice of the U.S. Supreme Court and first Jewish person to sit on the High Court. His parents, members of cultivated Bohemian Jewish families, had immigrated from Prague to the U.S. in 1849. Brandeis attended the public schools of Louisville and the Annan Realschule in Dresden, Germany, or Realschule, before entering the Harvard Law School, from which he graduated the head of his class in 1877. After less than a year of practice in St. Louis, Missouri, he moved to Boston, where he maintained an active and prosperous practice until his appointment to the Supreme Court in 1916. At the bar, he became known as the People's Attorney by virtue of his representation of interests that had not commonly enjoyed such formidable advocacy. When the affairs of the Equitable Life Assurance Society of New York precipitated widespread alarm in 1905, Brandeis became unpaid counsel for the New England Policyholders Protective Committee. Eventually, to remedy abuses by life insurance firms, Brandeis devised a system used in Massachusetts from 1907, New York, and Connecticut, whereby life insurance was offered over the counter by savings bank at rates within the means of workers. From 1907 to 1914, he defended against charges of unconstitutionality, statutes of various states prescribing maximum hours of labor and minimum wages. At that time, he devised what is still known to lawyers as the Brandeis Brief, in which the economic and sociological data, historical experience, and expert opinions were marshaled to support legal propositions. His most notable book, a volume of essays, Other People's Money and How the Bankers Use It, dealt with the control exercised by the investment bankers over the American industry. His work attacking monopolies and interlocking directorates influenced the passage in 1914 of the Clayton Antitrust Act and the Federal Trade Commission Act, which strengthened the government's antitrust power. Brandeis' support of Woodrow Wilson's theory of enforced competition among businesses was repaid on January 28, 1916, when the president appointed him to the Supreme Court. There was bitter opposition by numerous business interests and anti-Semites. Remember, he is Jewish. The nomination was confirmed by the U.S. Senate. In his other major judicial opinions, he expressed mistrust of both the unlimited exercise of government power in the name of the people and a conception of economic activity affecting and a conception of individual liberty, resorting in the agreement of a few persons to monopolize an economic activity affecting everyone. He believed that to preserve federalism, state legislatures had to be able to make laws suited to varied and changing needs, but he wished to restrict state laws when they interfered with the freedom to express ideas. In the case of Charlotte Ann Whitney, Whitney versus California in 1927, a communist who had been convicted under a state criminal syndicalism statute, he delivered a concurring opinion urging that penalties on speech be applied only if they met the clear and present danger of inciting to admittedly illegal acts test formulated earlier by Justice Oliver Wendell Holmes. Observing the procedural limits on the court, however, he voted to affirm the conviction because Whitney's lawyer had not properly raised the constitutional free speech issue in the trial court. Obviously, he had dissented when the Supreme Court upheld convictions under the Espionage Act of 1917 for publishing criticisms of the U.S.'s entry into World War I. On the most important issues, Brandeis was aligned, often in the minority, with his colleague Oliver Wendell Holmes. During the period of the New Deal, however, many of the dissenting opinions of Holmes and Brandeis came to be accepted by the court. While Brandeis' supported the constitutional validity of most New Deal legislation, he did not do so indiscriminately. He joined, for example, in the court's decision holding the National Industrial Recovery Act of 1933 to be unconstitutional. He would retire February 13, 1939. From 1912, Brandeis was an enthusiastic supporter of Zionism, which early on it's just like, let's bring Jewish people and have them a home in what was Israel. The only cause with which he was publicly identified. Brandeis University opened in 1948 in Waltham, Massachusetts, and was named for him. So yeah. Intelligent man, very important when it came to setting a lot of the ideations in the courts. So yeah. Had a wife he married in 1891, Alice Goldmark. 2 children. He became a big member of the Zionist movement, apparently, in an attempt to push back on anti-Semitism in Europe and Russia, and as a way to revive sense of the Jewish spirit. So yeah. He was raised in a secular Jewish household, so even though he was ethnically Jewish, they didn't practice necessarily. But yeah, his parents were originally from Prague, Bohemia. Then part of the Austrian Empire, and now part of the Czech Republic. So yeah. Was a Republican before 1912, Democrat after 1912. So yeah. Like the parties would go through their eventual switch, he kind of went through a switch. But yeah. Louis Brandeis. But we'll go ahead and end this episode there. As always, educate thyself. Think, read, study, learn. Someone tells you something you have trouble believing, ask them to cite their sources. I'll be putting my links and sources in the description box below the video. Thank you all for watching. I'll see you all in the next one. Until then, later.